Well, ladies and gentlemen, it seems that evil has once again prevailed because a federal judge has just officially thrown Justin Baldoni's entire lawsuit in the garbage. And if you can hear fire trucks in the background, that's because my backyard is literally on fire and I may have to evacuate in the next 30 minutes. And I still took the time to read the entire judge's ruling for you, which was 132 pages. So let's get into it. And I can't think of a better backdrop than my house possibly burning to the ground than to bring you guys this horrible, shocking news. So I am not going to sugarcoat this for you guys. A federal judge by the name of Louis J. Lyman, who apparently has no backbone or neck, has officially thrown out about 80% of the claims made by Justin Baldoni in his countersuit to Blake Lively, most notably the claims around defamation, which was the biggest one, false light, which fell apart because of the defamation piece, and also civil extortion. So this was a very lengthy document and it's very nuanced. I'm going to take you guys through every single claim that was dismissed so we can fully understand exactly what went wrong. And also, for the first time ever, today's video is actually sponsored by me. So if you would like to check out the herbal supplements made by me and my grandmother, you can click the link in our bio. So the first claim that was made and that was dismissed by the judge, and possibly the only part that I honestly agree with, was the claim for civil extortion. So according to California law, civil extortion occurs where a plaintiff gives a defendant money or property under threat, under duress, like you're threatened and you give somebody $1,000 and then you seek to have it back. And then specifically, it has to occur where someone acquiesces, like they give you what you wanted, and then you suffer damages as a result of this, okay? That's sort of like the generic version of what the legal standard is in order for that claim to be valid. In the case of Justin Baldoni and the way that his legal team tried to spin it in his favor was, for example, remember when Blake Lively tried to force Justin Baldoni to release a statement basically taking full accountability for the negative press coverage that Blake experienced, saying that Wayfarer and the entire set of Evidence with Us was a troubled production, etc., etc. She wanted a fall guy for what went wrong. They never actually released that statement. So just objectively based on the facts, it didn't meet the legal standard for civil extortion, and that kind of makes sense to me. So in this case, the judge rightly points out that, listen, in this circumstance, you did not acquiesce. Justin Baldoni did not release the statement that Blake Lively had threatened him and told him that he must release. He didn't give in, and then therefore he, one, didn't give in, and number two, couldn't suffer damages as a result of giving in, and therefore it did not meet the standard and there was no cause of action. It stops there. The judge also goes on to explain that many of the threats made by Blake Lively was not her threatening to do something, but her threatening not to do something. If you don't let me edit the movie, then I'm not going to promote the film. If you don't let me wear this disgusting, ridiculous outfit, then I'm not going to attend the premiere and I'm not going to promote the movie. So because of that, he says that those issues really should have been litigated under the cause of action regarding breach of contract and not civil extortion, which does make a lot of sense. And then the judge further acknowledges something which I do believe is also true, which is that the Wayfair parties didn't do a good job articulating the exact contractual obligations that Blake Lively had to Wayfair Studios. In fact, they sort of ambiguously refer to there being an employment agreement, but there's some confusion around when she signed it, her not wanting to sign the contract, at what point she did sign the contract, and what was exactly written inside of it. So now that they've been given leave to amend their complaint specifically regarding breach of contract, I'm very curious to see if we're going to finally get to actually visually have a copy of what Blake Lively's employment contract was and what exactly she was in breach of. So the next claim that was dismissed by this man, and arguably the most important one that has really gutted his entire lawsuit, was the claim regarding defamation. So the reason why this was dismissed was for two main reasons. The first being that the vast majority of what Blake Lively alleged, regardless of if it was factual or not, regardless of if there was malice or not, or if it was defamatory, were made within the confines of a complaint she filed with the California Civil Rights Department. So in California, if you want to sue for something like workplace harassment, you have to file with the Civil Rights Department first and then receive a right to sue letter, which you then, there could be an investigation that occurs, and then at that point in time, you are fully allowed to sue, which is what Blake Lively did. So because of this, it was covered by absolute privilege. And then to make matters worse for Justin Baldoni, all of the claims made after from Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times all emanated from this original filing, which is privileged. So because of that, the defamatory argument really falls apart. Now, the second reason the judge states why the defamation claim was dismissed was that Baldoni failed to prove actual malice. This reasoning I read in a lot of detail and I have a huge problem with, because actual malice refers to a circumstance where someone knew what they were saying was false and they said it anyway, or they acted in complete and utter disregard, reckless disregard for the truth. This is very subjective because it seeks to understand someone's state of mind, and how do you prove in a court of law whether or not Blake Lively believed what she was saying was true, whether or not Ryan Reynolds believed what he was saying was true. And regardless, at this point in time, he doesn't need to prove beyond a shadow of doubt that they knew what they were saying was false. He just needs to make it plausible. And I feel like with the facts laid out, it is very possible, and in my opinion, very obvious, that Blake Lively and Ryan Reynolds acted with actual malice, and I just really did not like this reasoning from the judge. This part of the judge's ruling really bothered me because it was intellectually inconsistent with everything else that I read from him. So for example, he talks about the fact that Leslie Sloan told someone at WME and others in the media that Justin Baldoni was a sexual predator, branded as a rapist. He goes on to say that that can form the basis of a defamation claim, but then he says, however, the Wayfair parties have not alleged that Sloan, who was Blake Lively's publicist, or Ryan Reynolds, her husband, had knowledge that the statements they are alleged to have made were false or that they entertained serious doubts to their truth. But the reason that there may not be concrete evidence of this is now the judge has stripped Justin Baldoni of his ability to pursue a discovery process where he very well could have found circumstantial evidence proving that Leslie Sloan had serious doubts that Justin Baldoni was truly a sexual predator, and now we'll never know. And this points to a much larger issue with the law, which is actual malice can rarely be proven, and in real-world circumstances and in real-world trials where we have examples of this in the past, it has to be inferred from evidence. So it's very unlikely we're going to find a text message that Blake Lively sent where she said, "I know everything I'm saying is a lie and I'm going to say it anyway." And honestly, actually, now that I said it out loud, knowing that actually is possible, right? But now we'll never know because the judge at the pleading stage has improperly completely dismissed this. As well, he is supposed to make all reasonable inferences in favor of the plaintiff, in favor of Justin Baldoni. Reading his reasoning specifically regarding actual malice, it felt like he was giving every single benefit of doubt to Blake Lively, Ryan Reynolds, the New York Times, and Leslie Sloan. So to summarize, the judge basically said, I want concrete proof of actual malice before the discovery process ever happened. It's sort of like when you're applying for a job and they're like, well, I want work experience. And you're like, I don't have work experience, so they won't give you the job. And then it's like that impossible loop. And then the issue is that the reason that Blake Lively and Ryan Reynolds had all of this documentation is because they illegally obtained it through a fake lawsuit that they filed and basically had a secret underground discovery process before them. So they got a head start. And he completely disregarded this. And in regard to dismissing the New York Times, the other part that he completely ignored was the fact that the New York Times actually included things in their video that they posted and the original article inside a Hollywood smear machine that excluded things that were said in the California Civil Rights Department. So this idea that everything that they said was privileged is not true, and therefore would not fall under the fair report privilege because they spoke about things outside of the legal filing. So I still think it should be brought before a jury. And lastly, a very important topic of conversation is the fact that Judge Lyman actually has vested financial interests in companies directly linked to Blake Lively and Ryan Reynolds. At first, I thought this was complete and utter bullshit until I looked into it myself, and I created a spreadsheet for you guys so you can directly see the stocks owned by Judge Lyman and the ways that they are directly involved with Blake Lively and Ryan Reynolds. It's insane. We are talking CBS and Viacom, which did Gossip Girl. We're talking Discovery Plus, which just did a documentary with Blake Lively where she was talking about the penguins like this.
They toil.
We're talking Lionsgate, A Simple Favor, Liberty Media, which owned F1 along with Ryan Reynolds, Amazon, which is another simple favor, Apple, and T-Mobile. According to the law, a judge must recuse himself where his impartiality might be reasonably questioned. The judge should recuse himself purely because of the appearance he may be unfair.